My name is Michael Young, and I'm a lawyer who handles estate disputes. A common estate dispute that I see doesn't necessarily involve the validity of a will, such as in a will contest, but people fighting over what the terms of a will means. And that can have very important implications as to who's supposed to receive what assets. The way that a court resolves a dispute over the terms of a will is typically via what's called a declaratory judgment action, where someone asks the judge to decide what the terms mean, and occasionally maybe even a jury decides it. So when a court or a jury looks at a will and there's a dispute over what the terms mean, the most important thing that they do is to try to determine the intent of the testator. That's the cardinal rule. But what a lot of people fail to understand, including a lot of people who call me to seek my guidance, is that that's not a free-for-all. That does not allow the parties to start saying, well, this is what I think he really meant, and he told me this is what he really meant, or there's an audio recording of her saying this is who she wanted to have to receive the property. That's what's called extrinsic evidence. That's evidence that's outside of the terms of the will. What the court will first do is to try to look at the words that the testator actually used to try to determine if there is a specific meaning that can be read from those words. And if there is, that's what the court will enforce. The court will not go beyond the meaning if someone says, well, that doesn't really make sense to us, or we don't like that, or that's not what she really meant. That is not what a court in Texas can do. The Texas Supreme Court says the court has to enforce the terms of the will as they are written, not how the court thinks that they should have been written, or what somebody says what the testator really meant, or these are the words that he or she really meant. It can't work like that. However, if a court should find that there's really no way to pin a specific interpretation on the words that are used, then a court can essentially declare that the meaning is ambiguous, that there's really no way to put a clear interpretation on the words that are used. And in that situation, then the court can resort to extrinsic evidence. When the court resorts to extrinsic evidence, that does open the door to testimony. Potentially the drafting attorney can testify regarding his or her recollections of what the testator wanted. You can look to emails, maybe letters, testimony of witnesses regarding the circumstances surrounding the execution of the will and the property, and to provide that evidence in support of their interpretation. But that's the only opportunity, really, the only time when the court is supposed to consider extrinsic evidence. Otherwise, the court's job is to try to interpret the words that the testator actually used.